We'll call the meeting to order. This is the City Commission meeting. It's Monday, April the 22nd, 2024. The time is 5:32. If you'd please rise for the invocation and the pledge. Heavenly Father, we ask that you look over this group tonight, that you give us the wisdom to make good decisions for the city of Leesburg. We do this in your name. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We'll begin tonight. We have a proclamation. It's Municipal Clerk's Week. Hey, hey. Whereas the office of the municipal clerk is a time-honored and essential part of local government that exists throughout the world, and whereas the office of the municipal clerk is the oldest among public servants, and whereas the office of the municipal clerk provides the professional link between the citizens, the local governing bodies, and agencies of government at other levels, and whereas municipal clerks have pledged to be ever mindful of their neutrality and impartiality, rendering equal service to all, and whereas the municipal clerk serves as the information center on functions of local government and community, and whereas municipal clerks continually strive to improve the administration of the affairs of the office of the municipal clerk through participation in education programs, seminars, workshops, and the annual meetings of their county, state, and international professional organizations. And whereas it is most appropriate that we recognize the accomplishments of the office of the municipal clerk, now therefore I, James A. Burry Jr., Mayor of the City of Leesburg, do hereby proclaim the week of May 5th through the 11th, 2024, as Municipal Clerks Week, and further extend appreciation to our municipal clerks, Andy Purvis and Anna Rodman, and to all municipal clerks for their vital services they perform and their exemplary dedication to our community. Now you can clap. Move on to item 3, it's presentations. We have none. Item 4 is public comments. This section is reserved for members of the public to bring up matters of concern or opportunities for praise. Issues brought up will not be discussed in detail at this meeting. Issues will either be referred to the proper staff or will be scheduled for consideration at a future City Commission meeting. Comments are limited to 3 minutes. And if you come up, would you please give your name and your address? Any public comment?
Bill Polk, City Leesburg, 600 Cascade Avenue, Leesburg, Florida. They had a bass tournament last weekend. It was a big success, I think. But we had big problems with boat ramps. People that are paying taxes here couldn't get their boat in Lake Harris, period. They said in I don't know what it was, email or Facebook or something, Al Menard sent out something that said they could put in at the ballpark and they could park at the old ballpark, but there was people down there that told them they could not park there. So no one could put their boat in Lake Harris from the 3 boat ramps that we have on South 27, Ski Beach, and or the ballpark. So in the future, I would I'm all for the fishing tournaments. They're great, bring money to Leesburg and all that. But somebody needs to reserve at least one of those boat ramps for the people that pay taxes on those boat ramps here. And I'd appreciate it if y'all look into that. Thank you.
Thank you. Lay brother Stephen Gerard Sidlowski. I'm a snowbird. My voting address is 1109 West 8th Street, Lorraine, Ohio. And as you know, beloved mayor, council, citizens, I'm here for the third time now, and I'm here to lovingly guide you in a new direction for your wonderful city of Leesburg. This new direction consists of 2 steps. I'll be providing this information to your city clerk before I leave. Step 1 is to first place the proposed personhood resolution on your city council agenda and then pass between Mother's and Father's Day. Step 2 is to amend your city charter with a new preamble covenant personhood language that will be voted on by the citizens this November. You will have to pass the ordinance resolution, however, by July in order to submit it to Lake County Supervisors of Election because step 2 date cutoff is August 23rd. I recently learned that by contacting your Lake County Supervisors of Elections with the loving guidance of your city manager. Please ask your city manager to notify you when your agenda embraces step 1 and step 2 so that I will have the 3 to 5 days to prepare the appropriate personhood education brief to all of you. You will find this personhood education edifying and persuasive. You will be personally invested and enthusiastically amplifying the new direction of a future Leesburg personhood city. Personhood cities are constitutional and will also legally oppose the new Florida amendment for that you will also be voting on this coming November. I always like to conclude with a little holy scripture because I think we all need to be edified in that direction. So let me please read, since I have time remaining, Psalm 78. For he established a testimony in Jacob and appointed a law in Israel, which he commanded our fathers that they should make known to their children, that the generation to come might know them, even the children which should be born, who should arise and declare them to their children, that they might set their hope in God and not forget the works of God, but keep his commandments. And a closing song I think you'll enjoy. The joy of the Spirit of God is love for his creation. I'll give the handouts to Andy now, if that's okay.
Other public comment?
Well, I think we're in evening, so good evening, early evening, City Council. My name is June Presley, and I am a resident. I live at 3175 Bright Lake Circle, Leesburg, Florida. And I just want to bring to attention a situation that I'm sure most of you are aware of, but living down there in this section where it's Highway 33 South and Highway 48 West and 470 at our little intersection, Okahumpka, has turned into a fiasco. And it's very difficult, very dangerous when we're trying to go and come from our little intersection there. We have people that are seriously cutting people off because we have no left turning lanes. People coming up from the Groveland section on Highway 33, when they get up to do a left-hand turn, if they want to go to the turnpike or if they're trying to get to the villages, holds up that entire section. I'm hoping that you all are communicating with the planning and zoning and the infrastructure people at the county level so that you are communicating the growth that we're experiencing by adding almost 800, almost 1,000 homes off of Highway 33 That will now be in the making. Plus, we also have the added homes that have come in from the villages on the 470 side, which is 48 or used to be 48. So it's where the Oklahoma post office is. It's almost impossible to get in and out of there in the afternoons or in the early mornings. My mother, who's 86, was hit there. She is a resident of our community for almost 60 years. And it was not her fault. I thought, gosh, it's her age. She, just finally had that accident. It has become very stressful and people are starting to road rage. Also, when we have people coming off the turnpike that are coming down 470, trying to get over to 27, that also becomes a very precarious moment because we only have 2-lane roads. So everybody's doing everything that they can to get to work or get home from work. I'm a teacher at Carver Middle School, and it is just difficult to even get in some days. When we get up to 27 and what we call Dixie Highway, that's mass bedlam. I'm sure y'all are aware of that. So I just want us all to be mindful and be present in what we're trying to do to accomplish good things for Leesburg, because I know all of you are. And I know one of our city councilors very well, and I know that she's doing her very best as well. So just think about our community. We want growth. I'm not sure how fast we should be doing growth if our infrastructure is not allowing it. The last thing I'd like to share with you is that working on what I call middle of Leesburg, where I live, we just had a home built that was annexed by City of Leesburg. It is south of Oklahoma, but I have been given Groveland as my post office, not Leesburg, not Oklahoma. I cannot get to Groveland Monday through Friday before they close. And our section, I thought, from A.B. Merritt Road north was supposed to be kept within what I call annexation of Leesburg, but they have annexed sections of where I live, Groveland. So they just handed our post office off our route to the Groveland section because I understand Leesburg is at capacity. So again, being mindful with almost 1,000 homes going into South 33 below Oklahoma. And there's my time. So thank you very much. I hope you'll take into consideration what I had to say, and thank you very much for your duty to our community. Thank you.
Al, Al, is there anything in the works or anything on that intersection of 48 and 33? I mean, that's all county, right? That's gonna be a county intersection, but you're not aware of any. Can you check with him on that?
Commissioner Canal, I don't know, it's just so everybody here, so everybody hears the conversation. Commissioner Canal asked me if there was any road improvement projects in the work for the intersection of 470, 48 and 33 there. The answer is not to my knowledge. All of those are county and or state roads, which would be governed by the county projects or state projects. I don't believe the county in the 5-year plan had any improvements for those areas. Most of the county 5-year CIP projects are in South Lake. I believe there's one project on 466A up in Fruitland Park, which is a county project. And then the other issue the speaker brought up was about the post office stuff, and that those would be a post office matters. But I will get back with Public Works and make sure they have our input as far as the roads go there at 33, 44, and 470.
Good evening, everybody. How you doing? My name is Maddie Akins. This is my second time to this meeting. The first time I had brought up a situation was I purchased a home here in Lake County. And I wrote a letter to you, Ms. Berry, about some issues that I had. And after the last meeting, I didn't speak. So I'm back again to speak on the same issue. The back of my home is the consider of Lake County. And y'all did a little accomplishment, but it's not a good enough accomplishment what you did. It's still trees need to be trimmed, still leaves and debris need to be picked up. Um, I'm asking for lighting and lighting back there because I am a single woman and I do want to be safe. And I had to invest into cameras where I couldn't afford it at the time to make sure, I'm in a renovation, getting the home renovated and everything, so no one can't be squatting. and everything. So it still looked bad back there. And at 808 East Magnolia, and I think that's Lake Street, back in there. And I appreciate that you did put like a handicap spot there for me and everything, but it needs more lighting in the back. And it's a church right there. The church is doing what they can do, but your area, it need to be clean. If you're expecting the community to keep their area clean, we are expecting for Lake County to keep their area clean, the alley clean also too. So if so, y'all don't want that to clean that, I'm asking for a permit or something that I could put a gate around my area to make my yard look like someone that lives there and appreciate their home and their home value of their home and everything. So, I never got a respond back for no one the last time I spoke with you off record, about getting back with me about those things. So I haven't heard anything back for anybody. So I'm just wondering, how soon can I hear for anybody about those issues?
We'll double check with Public Works. We'll be in touch.
Okay,
My apologies, but we'll be in touch.
okay. And you don't know how long it will be for any lighting to get back there, or where we can get these other vehicles from not being back there in the back too?
Okay.
Say that one more time.
It's on the side of Catrali. It's on Lake Street and Magnolia, and that one side street is the strip of the city's road that's needs to be decided if it's going, it's not a throughway street. It's just behind the townhomes, and it's right next to St. Pauli and Me Church.
Correct.
Yes.
If not,
Well,
let the owners
I need,
take that
there's,
piece
there's,
of property.
there's a bunch of tentacles in that, not to, not a bad word there, but just, I will personally contact you tomorrow. It looks like I got about a 3-department issue there, electric and a couple different divisions there in Public Works.
Okay.
So let me revisit that and we'll be in touch. My
Okay.
apologies.
I heard that last time, but I'm hoping this won't be again.
Understood.
I'm holding you to it. Thank you.
Any other public comment? We'll move on to the consent agenda. Routine items are placed on the consent agenda to expedite the meeting. If the commissioner staff wish to discuss any item, the procedure is as follows. Number 1, pull the item or items from the consent agenda. Number 2, vote on the remaining items with 1 roll call vote. And 3, discuss each pulled item and vote by roll call. Are there any items anyone would like to pull?
5B1.
All righty. Can we get a motion?
Motion to approve all remaining items.
Yep. Roll call?
Commissioner Connell,
Yes.
Commissioner Eastman,
Yes.
Commissioner Peterson,
Yes.
Commissioner Berry. Yes. Mayor Burry.
Yes. Would someone please introduce 5B1?
I'll introduce and ask to be read by title only.
Resolution of the City Commission of the City of Leesburg, Florida, authorizing the mayor and city clerk to execute an agreement for security access control system installation and configuration services with Source Link Communications, Inc., and providing an effective date.
For approval.
Second. Discussion?
Yes, I have a couple questions. This pertains to City Hall and the municipal building,
Yes, sir.
and you know what doors we're talking about on the 2 buildings?
Yes. So let me give you just a quick background. This project is a security project. It dates back to our goal setting session back last summer. And the concept was to ensure that our city facilities are secured. This came from different visits from the public, and sometimes the public's not altogether friendly. Generally, they are, like 99.9% of the time they are. But there is occasion these days where we get interesting visits where people are threatening, and it has set off, I think, some concern amongst city employees And as you can kind of see around the nation and here locally in the past several years, you see different municipal corporations as well as the county taking action to secure the facilities. So as we moved into this endeavor, and I don't mean this to be a long explanation, but I think it's important. As we moved into this endeavor, we had the discussion back at our workshop. We set it as a goal to make our facilities secure. And we did a little bit of an analysis of what facilities we thought were and were not secure. Facilities that we thought were secure, obviously the police stations and the fire stations, and the electric department as secured areas because the public has access to certain points, and then the rest of the facilities are literally locked down unless you're an authorized person. Some facilities we thought that we couldn't address because of the public access throughout the facilities. And so if there were safety areas in case of an emergency that employees could exit to, those department heads have worked with the employees on that. Namely, that's the library. There's really no really good way to secure the library because the public has access throughout that facility. So if an unfortunate situation arises, Lucy has worked with her folks on a plan on how you secure yourself. That leaves really basically two facilities that have a lot of public access that are very open to the public right now, which is City Hall and what do we call that? The LRMC, or the acronym for it. And I call it Dan's office. So across the street from City Hall, the old library, the old Sears building or JCPenney building, there is 4 public departments there. I'm 1, 2, 3, 4. Purchasing, which actually is locked off and secured from the access of the public. The building department, the planning and zoning department are not locked off and secured. And then IT is probably, I would say, reasonably locked off and secured. So the concept to secure these facilities to keep employees safe, but to allow people to come in is to move to a security system where all the doors are locked. And they're locked with automatic magnet locks, and employees and commissioners will be issued a pass, and I call it the swipey pass. And so you swipe the door and the access point, and then you can get access into the facility. And then each employee or each person who's issued a pass, that pass is then registered so that it allows them into access where they work and where they need to go. Employees would then receive those badges accordingly. So for example, let's say you're an electric person and you need to come in to see HR, you would have a pass, name badge, and you'd be able to swipe so you could get into City Hall. You'd be able to swipe so you could get up to the 3rd floor. If you were, for example, a member of the public and you needed to go in and see Jim Williams on the 2nd floor, the 2nd floor would be restricted. So you would go and you would see our customer service representative. Her name is Deb, by the way, who works out in the front. She'd sign you in, give you a pass, and then you would have access to that point, and then we would return the pass. That's kind of how City Hall would be locked down. I think there's 27 different doors that we've identified that need to be locked down. Basically, those are the big swinging doors that are on each floor. They're the exterior doors that go into the hallways. Each hallway has then a door, and the elevator. So if you've recently been to the county administration building, that system where you go in and you check in with the security agent and then you get a pass, that is the similar system that we would set up. Over there in the building and planning and zoning departments, that situation is a little bit different. Most of that area is secured, or some of that area is secured is a better word. IT and again, purchasing is secured, but that open lobby is not secured. And the way it's secured now is just by little divisional partitions with doors that open. So the plan there is to actually construct walls that go up enough of a way where we have security, but short enough that we still have airflow so that AC and heat or whatever can get around. And so that we don't have to invest in a major infrastructure project at that facility. And then those 2 doors now would be replaced with secure doors where employees, if you're a building apartment, you swipe there, you get in. If you're typically the public that visits now is typically stays in that foyer and they deal with a building, or they have an appointment with somebody in planning and zoning, and then we do that. So step one is to secure all these doors. So we did a bid, we did some research, and this item is about an $80,000 expense. It's $79,000 and some change to secure doors at City Hall, those 27 or so doors, and the 2 doors that will soon be at the other office. The purpose of this security badge, rather than a key per se, is that the security badge tracks who goes in and who goes out, so we can monitor that, and it gives an added level of security versus then issuing out a bunch of different keys, which is seen more of a breach. That's why, that's why the swipey pass, so to speak. So step one, assuming that this passes, is we will install the security stuff over at City Hall first. And then the second step will be to start building the walls, which we think we can do internally over there at the Planning and Zoning Building Office. And then once those walls are secured, they will receive a door that's similar to the ones that are in this contract. So this contract secures all the doors with the operations that I just described. And then we need to build those walls. The budget that we set aside in fiscal year 24 was 150 grand. Right now we're at 80 of that. I think there's a couple of $1,000 or so de minimis kind of expenses into the research of this project. And so by you approving this resolution, we contract with that firm, and we spend about 80 grand to do the first and pretty big swipe at securing City Hall and the Planning and Zoning building next door.
You're gonna need a swipe pass to use the elevator?
Yes. So the elevator will also be locked down. So the primary entry points into City Hall, obviously the front door. Downstairs is pretty secure for the most part, but that's where we do have the most public in and out. Folks paying their utilities or opening or closing accounts. So there is a significant amount of public traffic that goes into that area. But there will be a swipey pass. The elevators will be locked down too, because the security breaches to get up to the second and third floors are the elevator and the stairwells. When we have obviously public meetings and there'll be kind of mass public input, then those facilities will be opened, but then closed down automatically after and before meetings. So you won't need a swipey pass for a commission meeting.
How about on a regular basis for vertical accessibility?
They'll be shut down.
So what are we doing for vertical accessibility on the second and third floors?
Employees will have swipey passes, and commissioners will have swipey passes, so you can have vertical accessibility to authorized personnel.
The public?
The public will need to sign in.
And then somebody will let them up there?
Yes.
Any other discussion? Roll call.
Commissioner Reisman? Commissioner Peterson?
Yes.
Commissioner Berry? Yes. Commissioner Connell?
No.
Mayor Burry?
Yes. We'll move on to public hearings. Tonight we have a second reading. Would someone please introduce item 6A1?
Just ask to be read by title only.
Excuse me. An ordinance of the city of Leesburg, Florida, in accordance with the special magistrate's recommendation pursuant to the Sunnyside Lake Landing Holding LLC and Cenizo Ventures Florida LLC versus City of Leesburg, dated January 15th, 2024, rezoning approximately 120.5 plus minus acres from PUD to PUD planned unit development to allow for 150 detached single-family residential dwellings units on a property located south of US Highway 441 and west of Sunnyside Drive, as legally described in sections 29 and 32 Township 19 South, Range 25 East, Lake County, Florida, and providing an effective date.
Move for approval.
Second.
Got it. We'll have discussion. Mr. Briones, would you please swear in anyone offering testimony tonight?
Yes, sir. If there's anybody here who's going to offer testimony, if you please stand and raise your right hand.
Yeah. If you're going to come up and talk, we need you to stand up and, yeah.
Do you swear or affirm that the testimony and evidence that you will provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you, sir. Dan, if you would come up.
Thank you, Mr. Mayor. Dan Miller, Planning and Zoning. This is a request for an ordinance to rezone approximately 120 acres that is generally located, as Andy stated, south of US Highway 441 and west of Sunnyside Drive. The proposed project contains 150 units on 120 acres for a gross density of 1.25 units per acre. You'll recall that this proposed PUD is a result of the special magistrate's recommendation of settlement in the recent Sunnyside Landing versus City of Leesburg case that was pursued under Section 70.51 Dispute Resolution Act of the Florida statutes. The special magistrate has recommended to amend the PUD in the following areas. Number one, the total acreage of the project was dropped from 139 acres to 120 acres. That's due to the additional tract on the east side of Sunnyside Drive being removed from the plan. The total number of units was recommended to be reduced from 159 total to 150. And then dropping that total number of units did slightly increase the size of certain open space areas and buffers adjacent to the nearest properties with existing residences. It was small, but it was there. All other requirements of that PUD, as you have seen before, have been maintained, including requirements for 50, 70, and 80-foot lots, design and architectural standards for the houses, 25-foot planted buffers around the perimeter of the property. There's also a requirement for a boulevard entrance, sidewalks, upgrading of Sunnyside Drive adjacent to this property, preservation of wetlands, and recreational requirements all remain as well. Understand that staff understands that the commission may want to make some amendments to this request. Thank you, Mr. Mayor.
Just for, if you would, these are some amendments that I think the commission should consider. And I've talked with Mr. Briones about these, and they've been shared with the developer. And there would be potentially 3 modifications that the commission should make an amendment to the motion. Was there a motion? Was there a motion yet? There is a motion. Okay. So you would need an amendment to the motion on the floor, and the motion on the floor is to approve the PUD. So the amendment would be to modify the motion on the floor in the following manners. A, to add our dark skylighting requirements that are in more recent PUDs. B, to add the tree requirement that are in our most recent PUDs, and I believe that's a tree for every lot, 2 trees for every lot. And C, to modify paragraph 15C of the PUD, which is the expiration paragraph. So that expiration paragraph would be completely stricken. And I'm not going to read what we're striking, but basically paragraph 15C would be stricken. That exists now with an expiration of 120 months, 10 years. And then kind of some wiggly language on if this happens, then this may happen. So the intent of this change is to have a more clear-cut, shorter, defined action if the PUD does not develop. And it's basically restricting it from the 10 to the 6. So the modification in paragraph C would be upon approval of this PUD by the City Commission, a development permit or building permit application must be submitted with the city for work related to 1 or more phases of the PUD within 6 years of this approval becoming final with no appeal pending, or the PUD will automatically expire unless otherwise lawfully extended by the city or Section 252.363 Florida statutes. In the event that the PUD expires, the property shall be governed by the zoning regulations applicable to the RE1 zoning district. So that's the language that the commission, if you amend, would strike and amend the motion those three ways. So we would need a motion on that if you want to do that. Essentially, the concept is let me kind of flush out the three significant points that 15C modifies. Obviously, one is the term of the PUD, a life of 6 years versus 10. Second, which is the last sentence I'll jump to, is a specific, if it expires because they don't pull permits, then it goes back to a specific zoning automatically, which is RE1 zoning, and that's a one-for-one zoning. And while it doesn't say there, a one-for-one zoning in this case is not 100 acres and a hundred, if you have 100, right, you messed me up there. You broke the, if you have, let's say you have 100 acres and you're only going to use 30 of it and you jam 100 into 30 acres, that's actually a net one for one. What we're looking for is a gross one for one. So that's what the RE1 is. It's 1 acre, 1 house. So if it's 100 acres, it's 100 houses. If it's 30 acres, it's 30 houses. It's not a net. And then the third one, modification, which is a state preemption. So just 252.363 of Florida statutes is actually a law that where state statute supersedes local planning law. And that's a statute that says essentially anytime the governor issues a state of emergency, however long that state of emergency is, a development entitlement gets expanded. So let's say a hurricane comes, the governor says there's a state of emergency in Polk, Lake, Sumter counties, and we're in that state of emergency for a week. That means the developer would have the expiration of the development would be 4 years and 1 week, right? Or if it happens and there's 2 years or 6 years, I'm sorry, if it happens and there's 2 years left, so anytime that state of emergency exists, that time gets automatically put on. I think that's a bit of an olive branch. I won't speak for the petitioners. Our council did speak with them. They seem amenable to the change. And it's a bit of an olive branch, I think, to allow the city to put a little bit more of a restriction that this PUD would expire before some of the other PUDs that we've recently approved. So if the commission likes those modifications, we would need a motion to amend.
Do we have a motion to amend?
So moved.
Any discussion on the motion to amend?
Yeah, just for clarification. So so the motion is to amend, and I would just change the motion to amend as described by staff, which is the 3-point amendment. Andy, you good with that? And you're
good with that, Mike?
Dan has the tree and street. Dan has the tree and street light language, and that's the language for 15C.
So let's have a roll call on the amended motion.
Mr. Peterson,
Yes.
Commissioner Berry? Yes. Commissioner Connell,
Yes.
Commissioner Reisman?
Yes.
Mayor Burry?
Yes. Okay, so now could we hear from the petitioner?
Good evening, Mayor, fellow commissioners. Brent Spain, Theriak and Spain, 1809 Edgewater Drive, Orlando, Florida, on behalf of the property owners and applicants before you this evening. And before I go through, and I'm going to try to go through it as quickly as possible, a slide presentation because we're all very familiar with the project. I'll state on the record that special counsel did reach out to me regarding the proposed modifications, and our clients are amenable to those. So we have no objection to doing those three things and shortening the PD lifespan. So with that said, I just want to jump into a quick PowerPoint. It's got more slides than we'll talk about, but we'll jump through them. The first two slides just go over the standards for rezoning. You all hear these on a biweekly basis, month in, month out, so I'm not going to go through these. The couple I just want to emphasize are the first two is one, obviously a PUD, a site-specific rezoning is a quasi-judicial decision. You all have heard that buzz term while you've been serving during your term, which means at the end of the day, your decision needs to be supported by competent substantial evidence. And then the second to last bullet point up there is that one of those things that can constitute competent substantial evidence are the staff reports from your local planning staff and your professional experts. So in this case, I'm going to end up introducing a binder, which is essentially historical public records related to this case, including from the prior PUD, but the staff reports throughout the history of this project have consistently recommended approval, and they're recommending approval tonight on the modified plan. Next slide, please. And then on this slide, I just wanted, for purposes of this evening, because it ties into the hearing from a couple years ago, is the last bullet point, and you probably saw some of this in the special magistrate's order, is at the end of the day, when you all sit there, you sort of put on your judge's hat instead of your normal city commissioner hat. In that type of role, you've got to apply the city's adopted criteria. So it's not a decision of, well, what do I think might be best? What do I just personally like? At the end of the day, the decision for you is whether or not a proposal, any proposal that comes before you, whether it complies with your adopted criteria. Next slide. And then just very briefly for the folks in the crowd, a few of the newer commissioners, how did we get here? We talked about this briefly at the meeting earlier last month, March 25th, but I didn't have a PowerPoint. But just running through it, this application initially started back in May of 2021. We filed the development application. It initially actually was for 164 units on the 139 acres. It got reduced to 159 prior to the public hearing. So the public hearing, that's the second bullet point in March of 2022. That's when you all, the city commission, then held a public hearing on that. That application was a little broader than what's before you this evening. As Mr. Miller indicated, the matter before you this evening doesn't include the 18.5 acres on the east side of Sunnyside Drive. So back in March, 2 years ago, you had an annexation, a future land use change, and the PUD. This evening, the only thing before you is a new PUD on the, what I call the parent tract, 120 acres. But back in March, it ended. There were only 4 commissioners in attendance. It was a 2-2 vote, which procedurally ends up being a denial. So within the 30-day time frame, our client exercised a few different rights, one of which Mr. Miller alluded to. It's what we call the special magistrate process under the statutes. We also, on the plan amendment that had failed, we filed for mediation as allowed under the Community Planning Act. And then we also filed what's called a petition for writ of certiorari in Lake County Circuit Court, which that litigation has always been abated. It's been essentially put on hold since it was filed as we work our way through the special magistrate process. Last summer, July of 2023, some of the folks in the room attended the special magistrate hearing. It was Special Magistrate Carlos Alvarez. If you're a Florida Gator fan, he's also known as the Cuban Comet and played on the Gators football and is in the College Football Hall of Fame. But he's practiced land use law for 48 years in Florida. So he was mutually selected by the city and my clients to serve as the neutral special magistrate. And in July of 2023, he held an all-day evidentiary hearing. So it wasn't just a show and tell. People got called as witnesses. They're put under oath and all that. We have to put on expert testimony. The city did the same. And both sides got to submit proposed orders. And in January of this year, that is when the special magistrate issued his recommendation. And as Mr. Miller alluded to, the conclusion, the ultimate conclusion was to recommend approval of the modified Sunnyside PUD that's before you this evening, and that denial of the same would be, and these are technical terms on the statute, unreasonable or unfairly burden the use of the applicant's private property. And as we all know, last month we were before you on the settlement agreement, accepting the magistrate's order, and that's where we are tonight, is on the second stage of that, and we're here tonight to implement that and ask for approval of the modified PUD. Next two slides. So this is just a project aerial. You all are very familiar with the site. So next slide. This is the existing future land use on the property. It's in the staff report, but it's estate residential, which is 4 dwelling units per the acre under the city's comprehensive plan. Next slide. And then this is the existing zoning on the property. Those who attended special magistrate may have heard this. The property is actually still zoned PUD as we sit here tonight, and has been zoned PUD. The issue was whether or not the prior PUD had expired or not expired. And that's what was the impetus for our client to initially apply for a new PUD, because the staff had indicated it was the city's position that the 2005 PUD had expired. But as we said here, it's still the same color in the map. We just don't have a PUD in place. And as Mr. Miller indicated during the special magistrate hearing, if my client went in today and asked for a building permit, the answer would be no, because essentially you have a zoning with no PUD on it. Next slide. And we can jump to the next one. So this is the revised PUD. A copy of it was attached to the settlement agreement. It's in the agenda packet. I'm going to go through a couple of the modifications that Mr. Miller touched upon. I do want to indicate that, as Mr. Miller stated, there are 80-foot lots, there are 70-foot lots, there are 50-foot lots. What's important about the layout, and it's difficult to see it up there, they're color-coded by dots on the lot. But all the exterior lots are 80-foot lots. Every lot that borders Sunnyside Drive is 80 foot. Every lot that borders an exterior buffer is 80 feet in width. The more narrow lots, so the 50 and 70-foot lots, are all interior on the development. So they back up to conservation areas or wetlands. Next slide. This pie chart is on the modified plan, but that just shows a breakdown. So it does show the yellow are 80-foot lots. So it demonstrates the vast majority of the development consists of 80-foot lots. And again, all the perimeter lots are 80 feet in width. Next slide. So Mr. Miller alluded to this some. These are distance measurements. And over the next few slides, I'm going to go through how the plan was modified. But the applicant removed 5 lots in key areas. And as a result of removing those lots, it resulted in increased distances from the nearest existing residences. So this shows on the northern part of the PUD. You'll see the houses to the left on the bottom in my client's project. Those are 472 feet and 434 feet from the existing residential structure. And then the house up on the right side, sort of the northeast in that drawing, that's 263 feet. Next slide. And then these are the increased distances on the southern side. We have an increased buffer along the southern side. It's a 30-foot buffer instead of 25 feet. And then you also have, which I'll walk through in a moment, a reduction in the lots. So these lots are larger in size, but you can see the distances are 475 and 472 feet to that nearest residence. So by development standards, sort of what you probably see on a month in, month out basis, those are substantial separation distances between those houses. Next slide, please. So what did it look like back in, so 2005, there was a PUD approval, but the applicant at that time, the prior owner, actually came through the city and got a preliminary subdivision plan approved. That's what's on the overhead right now. This is a picture of the 2006 PSP. And again, this was reviewed and approved by the city. It was found compatible with all the surrounding areas. And I want to highlight the 3 areas on the plan because that's where we made modifications to enhance compatibility. So if we start sort of dead center, what I call the north lots, circled on the 2006 PSP, you'll see there were 5 lots in that area. If you go up on the top right, which I call the east, you have 4 lots. And then when you go down on the southern border and you see them circled in red, there are 6 lots on the southern side. Next slide, please. So when you compare that to the modified plan, you'll see that the northern spot up there in the middle of the slide, we have eliminated 2 lots versus the 2006 approved PSP. So we have 4 lots. And as a result, again, that increases that open space immediately to the east, which helps increase the separation from the existing residences to the north. The area on the east at the top, that's exactly the same as the approved PSP from 2006. It's 4 lots. And then down on the south, where on the 2006 PSP, it was actually 6 lots across that bottom, which again had been found compatible by the city. We've actually increased those, so those lots are substantially larger. There are only 4 lots along that southern boundary. And you'll see off to the right on the slide, there's a quote out of the special magistrate order for the folks in the crowd, and I'm quoting from page 29. From a strict compatibility standpoint, the revised Sunnyside PUD concept plan is not only an improvement over the 2021 Sunnyside PUD submittal with 159 units, which the city's planning staff deemed compatible with the surrounding area, but it is an improvement over the 2006 PSP that the city approved. Next slide. So one of the issues you may hear about this evening's compatibility. So I want to touch upon just a few points on it. One is there's a policy in the city's comprehensive plan. It was referenced by the magistrate, and that's FLU, Future Land Use Policy 1.6.5. And it provides in pertinent part, quote, compatibility with surrounding established neighborhoods shall be considered during the comprehensive plan amendment process. And why that's significant in this case is in the second bullet point, you'll see that in 2006, the city adopted a comprehensive plan amendment for this property and went from Lake County urban expansion, which is 4-to-1, and Lake County suburban, which is up to 3-to-1 dwelling units per acre, to city estate residential and conservation. And the city estate residential, as I indicated earlier, allows up to 4 units per gross acre. So presumably in 2006, when that plan amendment was adopted under the city's own comp plan, there was an inherent compatibility analysis done. And it was determined that 4 dwelling units per acre on this property is compatible with the surrounding neighborhood. But what did the city planning staff determine while this PUD was going through the process? Again, that's the third bullet point. The city planning staff had concluded, quote, the proposed request for a PUD plan unit development zoning is compatible with the current surrounding zoning districts, end quote. And his quote is consistent with the city's growth management plan, future land use element, goal 1, objective 1.6, which is land use compatibility. And then the last 2 bullet points are what the special magistrate, part of his conclusion. One was that there was no evidence or testimony introduced during the evidentiary hearing that would support a finding that the Sunnyside PUD would create a legitimate compatibility concern regarding any surrounding land uses, end quote. But then the special magistrate didn't just take all of our words for it. I think it's important for the folks in the room to know the special magistrate on his own, with no parties there to try to influence him or comment, did his own independent site visit, not only of the, what I call my client, the Sunnyside PUD property, but he actually acknowledged and stipulated on the record he drove the surrounding area and visited the surrounding area. And you can see, and this is a longer quote from him, I'm not going to read the whole thing, But he went out of his way to indicate this in the order that came back to you all, that he had done a site visit to the site and the general area, and that site visit did not disclose any grounds why the residential nature and density of the Sunnyside PUD, consistent with the revised Sunnyside PUD concept plan, would not be compatible with the surrounding residential land uses. And then he made note that he had practiced 48 years, so you all wouldn't think it was just a little puppy lawyer trying to tell, like, hey, I don't think it's compatible. It's an individual with almost 5 decades of land use experience. Next slide, please. So you all have seen this before, so I'm going to go through this quick. It's just so it's in the record. Next slide is one. We did submit an environmental report. This is an excerpt from the original environmental assessment. And then next slide, please. Based on some feedback when we were going through the original review process, the environmental consultants did an update. But as you'll see in the PD before you this evening, one of the conditions is our client has to come back before they actually do site development work. You always have to do an environmental assessment. One thing that probably is definitely out there are gopher tortoises, and as you all know, there's a process to go through to relocate those gopher tortoises or to preserve the areas. It's not, you don't get to entomb them like Florida unfortunately did many, many moons ago. So I just wanted that in the record. But again, there's a condition in the PUD. We'd have to do an environmental assessment as we get to site development work. Next slide. You may hear some about it tonight. You heard about it a couple of years ago, and it's in the magistrate's recommendation, but the traffic impacts. So again, there was a traffic impact study done. This is an excerpt from it. It had concluded that the roads were sufficient for the trip generation from this project and no level of services would be tripped. And that's, again, an excerpt from it. Next slide. So the last time we were before you, we had updated it with 2021 traffic volumes, and that's what this slide does to show that even after our project, accounting for our traffic, and I think it's important, the original traffic study analyzed 219 houses. With the 2021 numbers, when we updated it, we were looking at again at 164. But even here, it continued on the far right side. It will show you the number of available trips on those roadways even after our projects developed. Next slide. So then we had tried to predict out into 2024. This again was from the prior hearing, and to demonstrate to y'all there would still be capacity even after our project. So these again are those charts that demonstrate that there's available capacity after our project. We're not making or resulting in any roads failing. But then next slide, since the magistrate's order, we went and Lake County Public Works has new traffic counts for those 3 stations. So we looked at those 3 stations and said, okay, well, how do the new Lake County numbers for 2024 compare to the last numbers from 2021? So you'll see the 3 stations here. Station 451, that's at Sleepy Hollow, south of 441. So in 2021, the count from the county was 4,640 trips. The new 2024 numbers from the Lake County, not from me or my traffic consultants, are 4,730. So there's been an increase of 90 trips per day. So once you factor in our client's project and the trip distribution, the available trips after my client's project, there's still 197 trips available on that segment of roadway. You go to the next station, station 423, you have Sunnyside Drive west of Tomato Hill Road. And you can see in 2021, the counts were 2,709. And in 2024, the counts were 2,594. So there's actually been a decrease at that station of 115 trips. So after our client's project, you have available trips of 470. And then the last station, station 414, which is Sunnyside Drive south of the 3-way intersection, In 2021, the county's trip counts were 1,523. And in 2024, the county's trip count was 1,267, which is actually a decrease of 256 trips, which after this project leaves an available trip capacity of 764. And again, the source for that data is Lake County Public Works. Next slide, please. So this is a slide, this relates to testimony and evidence from the special magistrate hearing about pavement ratings. You may have seen that in the special magistrate order. It's hard to see the colors on that map, but they're colored green, red, orange, and yellow. And the area leading east on Sunnyside Drive down to the 90 degree bend in the road is orange, which based on the information from Lake County had a pavement rating of 8. And then as the magistrate had recognized in his order, when you get to my client's property, that pavement rating drops. And it's shown on here in red, which is 4. But then there's a condition in the PUD that requires my client to bring that segment of the roadway up to county pavement standards. And so the magistrate recognized that, and these are a few bullet points from his recommended order. Quote, the petitioner's traffic impact study was reviewed by the city as well as Lake County and Lake Sumter Metropolitan Planning Organization. Significantly, neither the city nor the other reviewing entities raised any issues with the petitioner's traffic impact study, which we've talked about that. In fact, there are more trips available now than when we did the traffic study. And then the second bullet again goes to the fact that the unrefuted testimony both from my client and the city planning staff at the hearing was that Sunnyside Drive has sufficient capacity to accommodate the anticipated traffic, and this is the more important part, quote, all segments of Sunnyside Drive will have a sufficient pavement rating following the development of the Sunnyside PUD as conditioned. So again, it's a requirement. My client's going to have to comply with that. The area that's on that map in red, that's along my client's border, and to its entrance, this community will have to be brought up with repaving. So again, the last bullet point is just to the extent the city commission's denial of the Sunnyside PUD was based upon traffic concerns or the perceived condition of Sunnyside Drive, such denial is unreasonable or unfairly burdens the petitioner's use of the parent track. Next slide. And so this is just sort of goes back to that point at the beginning, and it's sort of, this leads me into my conclusion slide, is the Sunnyside task report, which we all are very familiar with in the room. We heard a lot about it 2 years ago. It was the primary focus of the special magistrate hearing. It took up the majority of the day, I think, was testimony about it. And it took up a large part of the recommended order. But I want to walk through it so these documents or slides get into the record. So what's on the overhead before you right now, this is the resolution that you all are familiar with from back in June of 2004. And this has the language where the city council at that time purportedly adopted that recommendation, but then also included language that said, well, unless otherwise approved by the commissioner, by the city commission. So again, that was June 2004, not 2024, 2004, which is important for the chronology here. So next slide, please. So this had come up when the project was initially going through review. And these are some excerpts from the minutes from August 2020 and December 2020, where the former late city attorney, Mr. Morrison, had been specifically asked about the Sunnyside study and whether it was applicable to the property. And in the top bullet point, and I'm reading from the minutes, Fred Morrison explained that there is a proviso except as otherwise determined by the city commission. And they passed for first PUD. So that's like a typo. But then he went on, although the study was adopted in 2004, it is not considered binding on future city commissions. And then in December of 2020, it got brought up again. And former city attorney, the late Fred Morrison, indicated that in his opinion is essentially the same as it was the last time. It was implemented by way of resolution, which is important. The special magistrate touched upon that. And he went on to say the city commission has the authority, notwithstanding the task force report, to approve this if it is the desire of the commission. So that was before we went through a magistrate hearing, and that was the former city attorney's view of it. So next slide, please. So this is the 2005 PUD that was approved. This was approved in December of 2005. This was more than a year and a half after the Sunnyside resolution. And you'll note that in this 2005 PUD ordinance, the city did not apply the Sunnyside Task Force study report to the property in approving that 2005 PUD. In fact, at the magistrate hearing, both my consultant and the city's planning staff acknowledged that the 2005 PUD doesn't comply with the Sunnyside Task Force report. Next slide. This is the 2006 PSP, which you already saw a bigger picture of it. But again, this was approved in June of 2006, more than 2 years after the adoption of the Sunnyside resolution. And again, the city did not apply the Sunnyside Task Force study report to the property when it approved that 2006 PSP. Next slide. And then this is the 2006 plan amendment ordinance, which strangely the land use was done after the zoning on this property. Typically you see it the other way around, but this was approved in December of 2006. So this was the last approval of the 3 approvals. It was after the PSP was approved. It was more than 2.5 years after the adoption of the Sunnyside resolution. And again, when you look at the 2006 plan amendment, there's no language restricting the density below 4 dwelling units per acre or somehow subjecting the property to the Sunnyside Task Force report. Next slide. This is an excerpt from back then in 2006. You had to do what it was called an objections, recommendations, and comments report from Department of Community Affairs back in the old days. So you would do it was an ORC report. The city would have to do a response to that. This is a chart that was in the city's ORC response for that 2006 plan amendment package. In this chart, there were several plan amendments, one of which was Sunnyside Landing, but you'll see this is looking at trip generation. The scenario column on the left, it says adopted and proposed. So it's recognizing what my client's land use was under the county then. County urban expansion, 4 dwelling units per acre, county suburban, 3 units per acre, plus 50,000 square feet of commercial. And then what is proposed, it says city estate residential, 4 units per the acre. And then in the allowed development column, it says up to 480 units. So again, the indication that while this was going through the process, the intent was not to apply the Sunnyside Task Force report to the property. Next slide, please. This is the second to last slide. So these are just some of the key magistrate findings on this point. Again, the magistrate entered a 40-page order for the folks that are in the crowd. It's a public record. But he essentially focused in on 3 points. One was the historical evidence, and that's bullet points 1, which I've quoted 2 things from, but he indicated the testimony and historical evidence introduced during the evidentiary hearing established that the city did not apply the Sunnyside Task Force study report to the parent track in approving the 2005 PUD and the 2006 PSP, which we went over, and that the 2006 plan amendment also contained no language restricting the site. Nor does the future land use map include any asterisk or notation. So again, he focused on the historical evidence that the report was never intended to apply to restrict the density on this property. And there was a reference to the then former planning director's testimony back in 2006, where she had explained that, quote, the density in place at the time the Sunnyside report was approved are still valid. And the attorney at that time, Steve Ritchie, had demonstrated what the density on this property was under the county's future land use map and comprehensive plan. So then the magistrate went to a second point and said, even assuming the study report was intended to apply to the parent tract, that it would be unlawful to apply them because the density level limitations recommended therein are not codified in the city's comp plan or the city's land development code. And this was the point, Mayor, you had alluded to at the last meeting, that you all weren't on the city commission. You all aren't responsible for that, why there was that oversight or whether it was done purposely or not purposely, but that was an issue for the magistrate. And he indicated that given the undisputed fact that the city has never formally codified the recommendations of the Sunnyside Task Force study into the city's comp plan or the city's LDC, the density level limitations set forth therein are not legally binding and do not apply to the parent tract. But he went a step further and said, well, okay, well, even assuming that historically the intent was to apply it, and let's assume that it was how it was written, that somehow it can apply to the property. He then analyzed that the resolution as adopted has no objective criteria in it, which is very important under Florida law, because when you're sitting in a quasi-judicial capacity, you have to apply the adopted criteria and they have to be objective. And whether it's Leesburg, Orlando, Orange County, Seminole County, Lake, if they adopt a provision that just gives unbridled discretion to the board or commission to just do whatever it would like, Florida courts have said those type of provisions are unenforceable per se. And that was the last conclusion that the magistrate had reached, was that there are no objective criteria or standards that govern when that task study report would or would not apply to a particular parcel of land. And that to the extent it granted the commission unbridled discretion, it would be unenforceable under Florida law. And he cited a litany of cases to that effect. And then his final bullet point in his introduction, where he summarized his recommendation, quote, there is no land use regulation in Florida and likely in any state that is enforceable or valid under such circumstances. Such a scenario is the definition of unreasonable and arbitrary, and certainly unfairly burdens the use of the property. Next slide. And this is the last one, and I appreciate your all's patience, is we're before you this evening to try to bring this in for a landing. I mean, the mayor commented on, I think another commissioner commented on, it's been a long road for all involved, including folks in the room, my client, you all, your staff. And we're here this evening to ask you respectfully to approve the PUD consistent with the magistrate's recommendation and the city planning staff report. And it would be the modified PUD plan, subject to those additional 3 modifications that you all moved to impose this evening. And again, we submit that that modified plan complies with the city's comp plan and land development code. For the folks in the room, I would note the magistrate also, as part of his recommendation, did recommend that the city actually take the steps to implement the Sunnyside task report into its comp plan and or land development code so that this type of situation doesn't repeat itself in the future. So there is that. And I know from the mayor's comments at the last meeting that I believe you all are already in the process of doing that. So again, we're happy to answer any questions. As I indicated, its looks are deceiving, but I do have a binder I would like to introduce into the record. It has 35 tabs. Everything that's in here is part of the development file for this PUD, other than tabs 1, which is a hard copy of this presentation. But again, with the mayor's permission, I'd like to introduce this with the city clerk, and we're happy to answer any questions and would ask for a few minutes of rebuttal.
Mr. Spain. we'll accept that. Do we have questions for the petitioner from any commissioners? Any questions? Okay, so at this time, we'll have public comment. If you would please don't come to the mic and just repeat what the person before you said. Okay. Again, if you'd give us your name and your address.
Good evening, Zach Broom. I'm an attorney representing Mr. Tucker, who's going to speak on his own behalf as to the facts, but he asked me to briefly present some of the legal issues that we see here. Most basically, that I perceive when I've read the special magistrate's recommendation, and I want to clarify, the term order has been thrown around. I just want to be clear, he is not a judge. Okay, he's a special magistrate. He makes a recommendation. The case is actually still abated. A circuit court judge in Lake County will ultimately decide if you don't approve this tonight, whether or not there was competent substantial evidence to support the denial 2 years ago. So I just want to clarify that while we're here. But one of the things that he talked about was the future land use, and Mr. Spain talked about this heavily tonight, the future land use and the 3 units per acre and 4 units per acre. One of the things that's mentioned, though, somewhat as an aside, is that its current zoning is PUD going back to 2005. And the reason that I'm bringing that up is if you actually look at the 2005 PUD and the annexation agreement, you'll notice something interesting. The annexation agreement says the annexation of the parent tract, the 120 acres roughly we're here about tonight, is subject to the terms of the PUD that Mr. Spain was alluding to, this ordinance referred to from July of 2005. The reason that's relevant is that PUD set a density for this project of 1 unit per acre. More importantly, the special magistrate actually noted in his recommendation an interesting proviso of that ordinance. It explicitly says that when the ordinance lapsed, the applicant can come back and ask for the same density that the applicant had received, or they would get a lower density of the estate residential 1, not the future land use estate residential, the zoning, which, as you've heard, your staff wants to amend this application because that's a 1-to-1 zoning density. So this parcel coming before you tonight, they're talking about future land use. The PUD zoning that it actually had, which is somewhat from the special magistrate's recommendation, he thinks that it didn't go away. He thinks staff was wrong. The special magistrate thinks that there was no notice given, there was nothing done with the applicant. It doesn't clearly say what happens to the PUD. That PUD says 1-to-1, and it says if it expires, it goes back to estate residential 1-to-1 for zoning. This is 150 to 120, higher than 1-to-1. It's 1.25. The other interesting thing about that ordinance is that it mentions that it runs with the land. It does not tie into any sort of termination. So as a basic premise, the starting point, and this was all brought up back in 2 years ago in 2022, excuse me, the Sunnyside Task Force was discussed because if you go back and read the minutes that were introduced back in 2022, in 2005, staff, and I cannot pronounce her name, but Laura McEllannon, your community director in 2005, stated the reason you went for a 1-to-1 density in your PUD, even though the future land use was 3 or 4, is because of the Sunnyside Task Force report. That was why they went for the 1-to-1 density on the PUD. So even though the special master is correct, it was not codified into the land development code, the PUD that is the zoning for that property that the buyer bought with that knowledge is a 1-to-1 zoning, and the minutes from incorporation of that PUD reflect that the Sunnyside Task Force report was the basis for that decision. This parcel is mostly in the 1-to-1 density with a little bit 1-to-3, and there was a timeliness analysis that went on. And as a final point on kind of the legal issue, there's a lot of discussion about what you can consider. This state of Florida does talk about that staff can be competent substantial evidence. That does not mean that's the end of the conversation. That's why you're here. That's why you're a commission. You can take public comment as evidence. You don't have to take generic things, I don't like it, I don't want it. That kind of stuff you can disregard. That's totally correct. However, that does not mean that general public comment about specific concerns that are fact-based statements about this area, about the project, about the concerns can be competent substantial evidence. And more importantly, you don't have to win that you beat the applicant. The courts in Florida have been very clear, they don't reweigh the evidence. As long as this body heard evidence and decided we like that evidence better, that stands. It is not the job of the court to reweigh the evidence. And so from our standpoint, what was heard 2 years ago, there was absolutely competent substantial evidence to deny the 2-2 tie, and that essentially what the special magistrate did was reweigh the evidence and decide what he thought was the better outcome. So we would say that the PUD and that present zoning still controls on the 1-to-1. It's inappropriate for that area, and that the competent substantial evidence that was presented 2 years ago was sufficient to support that decision. Thank you.
I'm gonna agree with what Attorney Broom said. And in fact, if the applicant would have come in with the 1-to-1, like the underlying zoning is, this room would be empty right now. So, I want to speak more upon the way us residents. Oh, by the way, Murray Tucker, Greater Sunnyside Area Property Zonation, 6839 Tuscaloosa, Leesburg, Florida. Back on April 27th, they filed for writ. Y'all familiar with FLUDRA? Do y'all have the statutes? Would you like the statutes? Do you care? Anybody like to read them? Or you want me to read from them? Section 5. The governmental entity with whom a request has been filed shall also serve a copy of the request for relief by United States mail or by hand delivery to owners of real property contiguous to the owner's property at the address on the latest county tax roll. I get the letters from planning and zoning. So does my mother. 2 different addresses. None of us got anything. Nobody here got any notice this was going on. The statute requires us to be notified. Never happened. I've done a public record search. I can find nothing. Nothing in the newspapers, no evidence of letters, 0. And then we'll move on. Right after we found out that they had filed for writ, Zach and I filed as interested parties. And once again, I've got a whole list of dates here of your shade meetings, of the mediation that we were supposed to have received notice on. No, got notice for that 2 days prior, 3 days prior. Our attorney was out of town. I mean, 3 days notice on that. Lots of notices. The magistrate meeting on the April 25th, it went a newspaper on 4/16. The most important one is the actual hearing on 7/19. I've got a copy of the Daily Commercial. It was inserted on 7/16, 3 days notice. No letters to any residents per required. Per FLUDRA, you're supposed to notify us within 40 days. 3 days notice. How is it reasonable for working people to try and rearrange their schedules to come to a hearing and show up? And the magistrate dinged us because there wasn't a lot of people there. They said, no public. Well, duh. 3 days meeting, 3 days notice. That's against the law. It goes against the statute. Look at the last shade. All right. Sorry, I'm not a public speaker. So anyway, like I said, didn't know. So I found out about the magistrate because I happened to be with the mayor and the city manager at a Habitat for Humanity project, and he told me about it. I've got the records from the Daily Commercial. It's right here in my thing. I can give you a copy of it. Zach's email, name, address, and phone number is on the bottom. We're interested parties. There's no excuse for him to have not been properly notified. I had to tell him, hey, I heard from the mayor, we're having a meeting. Oh, he reached out to Briones. Oh, yeah, we're having a meeting. I mean, that's ridiculous. Magistrate's not a judge, you know that. Here, no, I'm gonna jump around a little bit here. The other night, I'm watching the the 4-1 Electric Advisory Board on TV, Lakefront TV. Yeah, Tim Morris chairs it. He's a good buddy of mine. I'm watching it. It's really funny. At the 30-minute mark on a meeting that happened on 4-1, the electric director gets up and starts talking about all the big projects coming up. And lo and behold, he says, oh, and a big one on Sunnyside. Hello? I mean, we haven't gone anywhere yet. And the electric department's already talking about doing it. Does that seem right? Now, here's the biggest problem I have whatsoever in talking with you commissioners and listening to what you had to say is the fact that all of you are sitting there and saying, well, we've been told we have to accept this. We have no choice. Our hands are tied. We have to do it. Well, no. I mean, last time I checked, y'all are the bosses. These guys work for you. This is the same development you turned down. Nothing has changed. We have shown plenty of evidence that if you looked hard, and I said the other day, postpone this, get a second opinion. I still strongly believe you ought to do it because I believe we can show that there's plenty of evidence that your denial was correct. Now, if it went back to the 120, we would not fight for lower because we don't think we deserve lower. But under the current laws, the 120, good. But the fact that this has all been so prejudged, I mean, you're not looking at this on the merit of the PUD. You're looking at this on the merit of what some attorney or somebody told you. That's what y'all said, almost verbatim. And because of the lack of notifications, the lack of due process, I find that this whole thing is very, very questionable. I think it needs to be looked into very carefully. Thank you. Oh, I got one more thing. I'm sorry, I forgot the last most important thing. Well, not most important thing, but it's one of the things. Here's the order filed by the judge when writ was filed for. The order says, line number 3, the petitioner shall file a status report with this court within 15 days of the completion of the special magistrate's proceeding, either dismissing this proceeding or requesting further action by the court. As of today, there's nothing in the court docket stating that it's been done. So this order has not been filed or followed. Another procedural due process. So thanks.
My name is Mark Arney. I live at 7393 Sunnyside Drive. I'm an affected resident within 200 feet of the proposed PUD. So I stand before you to request expert testimony. The reason I'm testifying as an expert is because I'm very familiar with the Florida land use laws and zoning regulations. Before moving to Leesburg from Orlando over 5 years ago, I served as my HOA's president. The PUD consisted of 65 single-family units. During the time I served under the HOA as a board member, ARC committee, and president. I participated in a number of interactions with local and state authorities and legal counsel. And on behalf of the HOA, we weren't incorporated. Our HOA was actually part of Orange County, so I had interface with a number of county officials, Orange County officials. So I'm very familiar with this. So let's start at this. Just give me 1 minute, please. This aerial shot was taken in my front driveway. I had to go up about 100 feet. Okay? All these trees will be gone. I repeat, all these trees that you see will be gone. Don't let them tell you otherwise. They will be gone. In fact, I had a conversation with Mr. Miller. I said, so Mr. Miller, what about the hillside development? For those of you that have lived here more than 5 or 5.5 years, you know, hillside development right up.
Mr. Arney, we need you at the microphone because no one can hear what you're saying.
Well, I always thought I projected pretty well, but okay, that's what my wife tells me. Um, so all these trees will be gone, all of them. I had a conversation with Mr. Miller a few weeks ago. I said, are we going to be looking at the same situation as Hillside? And Hillside was a smaller development, but again, it's on the corner of Old Treveri's Road and Sleepy Hollow. And those of you who lived here more than 4.5 years, you remember that was a wooded area. And the two developments that overlooked the trees. And surprise, the developer came in, took every tree down. And Mr. Miller told me, we have no control over the developer. He could do the same thing. Think about that. One of the most beautiful stretches of Sunnyside, every tree is going to be gone. Here's Sunnyside Drive. At the top, the road gets narrower. As you go down, for those of you who live in the area, you know that it's so narrow that you've got a couple little curves going down towards the lake, and you're in trouble if a big vehicle comes your way. There are corners that have as slow as 10 miles an hour to go around those corners. Mayor Barry, right before the 2-2 denial in March of 2022, he stated the exhibits that the developer showed included portions of Sunnyside where he said there are tire tracks along the road. And do you know why those? And I said, yeah, one of those tire tracks is probably mine. Because if you have a school bus, if you have a large truck coming from the other direction, you don't have enough room. You have to turn over, and that poses a serious problem. And it would be very serious and critical if you approve this. Now, let me point something else out. This is part of the proposal that I got from Dan. I think this is Appendix A. And this is supposed to apply to this HOA. The survey of trees on the property shall be conducted as follows. If existing on the property, all specimen heritage and historic trees shall be surveyed. P&Z staff, I believe, will review the tree survey, and such trees shall be saved wherever possible during the site plan review process. This may include amending the site plan to review and save specimen heritage and historic trees. A survey of 100 feet by 100 feet plots indicating that all protected trees 4 inches by diameter and larger shall be surveyed for each distinct vegetative area for use in the replacement area. Site areas that are to be preserved and existing trees do not need to be included, blah, 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 blah. Mayor Barry made a proclamation at the last meeting. He said that, I think it's 26th of April, you're going to be, Leesburg is going to be celebrating Arbor Day, Tree Day. How ironic is that? When we're here at this meeting 2 days prior, and all these trees are going to be down. It's not just the way the trees look, they provide a function. This area is prone to flooding. And you take all these trees down, and you imagine what's going to happen to our insurance rates from FEMA? Yeah, exactly. So now I want to turn to this. Could you bring up that slide that shows the PUD? Okay, thank you. Do you have that slide that you could bring up at the PUD, please? No, the other one. This one right here. Yeah. Okay, well, while he's looking for it, let's just point this area out. This is where I live. My neighbor is right here. And you can see all the other areas, the buffer zones, with the wetlands and the green space are there. Except for our area and these last 2 homes, you have a cul-de-sac that ends at Road C with 8 homes on either side. Attorney Spain made the comment that there's going to be hundreds and hundreds of feet between the existing structures. I have the quote. The developer, when concern was expressed by certain commissioners around December of 2020, they put them between the project and the existing residential homes which were walked through. Most of the lots do not abut to any existing residential. They abut to conservation and wetlands. The ones that do abut properly are very limited. Well, guess what? We're one of those limited. And there are hundreds and hundreds, I repeat, hundreds and hundreds of feet between them. Again, he respectfully asks for their approval so they can move forward and bring a wonderful project to the city of Leesburg. So, I'm going to go on record as not receiving a March 20th communication from the cities of Leesburg announcing that for all those on the public record located with 200 feet of the above referenced request, an application has been filed, and the case will be considered by the special magistrate. Get this. The case will be considered on April 24th, 2023. What? April 24th, 2023? I thought that meeting was in July. You said it was July 19th, July 23rd. And there will be no public comment will be heard because of the nature of the meeting. The nature of the meeting is supposedly a quasi-judicial. But I would present to you that it was more of a legislative issue. Legislative issues don't require as much formality than a quasi-judicial. In fact, on Amendment A, if you read the fine print, got to find it, bear with me here.
Mr. Ernie, I need you to wrap it up, please, sir.
Okay, Mayor. At the very bottom of this document, it says, revised March 4th, 2024, per special magistrate's recommendations, entered on January 15th, 2024, legislative format. Legislative format, not quasi-judicial. There's a whole different standards set for that. Supreme Court of Florida says that you can't just come up here and say, I don't like this development, so I'm gonna be opposed to it. You have to have fact base. And Mayor Barry, you did have fact base because you pointed out that those tire tracks were fact based, introduced evidence by the plaintiff now, and it's a safety hazard. And I'm sorry, just one more thing, and I will wrap it up. One more thing. Chapter 166, Florida statute provides municipalities with broad powers to adopt zoning regulations, which set regulations for how property can be developed and what specific uses. Zoning laws are in place to regulate land use in the public municipality to serve the health, safety, and general welfare of the public. Florida law has also weighed in on what constitutes a legitimate public purpose. Should the local government consider denial of the rezoning application? A legitimate public purpose can include general public health, safety, and welfare issues, such as traffic safety concerns and the impacts on the local environment. So, the Supreme Court of Florida has defined substantial evidence as such evidence will establish a substantial basis of fact, which one fact can be issued and reasonably inferred. There are also penalties. Proper notification isn't given. Your attorneys can refer to the sunshine provisions. If it's intent, provisions and penalties can range from $500 fine And I'm not accusing anybody of doing anything on this, but there are provisions you need to be aware of your attorney. I'm not an attorney, so I can't make you aware on the consequences of improper notification, not only improper notification, but the type of meeting. When I get this letter that says nobody can testify, that's not true. That's not true. Thank you.
Have any more public comment?
My name's David Calton. I'm a resident of Sunnyside, also an officer of the Sunnyside Homeowners Association. And I'd just like to bring back to you the issue. Council says that book has everything you need to know about this package and this development, except it does not show that the owners of the development are properly registered with the state of Florida. And they are required, they're required to file, they're required to pay an annual fee, and they have not done that. And they didn't do it after being told at a prior meeting. So I'm concerned that you can't believe what they're telling you. The other thing I would like to ask is, how many of the councilmen have actually spent any amount of time driving the roads at Sunnyside? I cannot believe that that's the most important thing that y'all need to be doing. And probably would get a whole bunch of hands raised if I asked how many people here tonight have had wrecks or been run off the road. It happens very frequently. And based on what you see at where Sunnyside meets, or where Sleepy Hollow meets the highway, we're rapidly becoming one of the most accident-prone roads there is. And yet we have a study done by the applicant that says the road traffic has gone down. And I would suggest that common sense dictates that that's BS. Thank you.
Bill Polk, 600 Cascade Avenue. Prior property owner of Sunnyside, grew up in Sunnyside. Are y'all afraid that the special magistrate is all what's happening? The citizens of Leesburg are telling you what they want. And you're letting a magistrate who said, Mr. Spain said the special magistrate made a recommendation. That doesn't mean you have to vote for it. You do not have to vote for it. You can vote against it. Plus, you have 40% of this project is 50-foot lots. Is that zero lot line, Dan? Or that's not zero lot line? What the heck is it? You can't put a tree on a 50-foot lot, and they're requiring 2 trees per lot. It doesn't work. Go to the villages. They got trees in the medians. They don't have any trees around the homes. They got bushes, maybe. And one more thing, you know, this is just a recommendation. Don't be afraid to vote against it, or whatever the way that the Sunnyside people want is. Mr. Spain said you had a Carlos Alvarez come and speak to you. He was a record holder at University of Florida in 1969 through 1973. But he's also a conscientious objector in Vietnam during the Vietnam War and got banned from the team. So you're listening to that man. So I'm sure the veterans appreciate Carlos Alvarez.
The public comment. Mr. Spain, as the petitioner, do you have any other comments?
Yeah, Mayor, I'll keep it brief. If I could have my PowerPoint brought back up to the conclusion slide, please. And while that's happening, I'm going to just jump through a few of the points that you heard. One from Mr. Brum, the attorney, the suggestion that when the PUD expired, it automatically reverted to RE1. So a one dwelling it to 1 to the acre, 1 to 1, which is not the case. In fact, that was a major point at the magistrate hearing. It's touched upon in the order. The city planning staff acknowledged that none of the steps were actually formally taken to implement that revision or rescission section. In fact, that's part of the reason for the clarification on paragraph 15C in the current PUD is so that type of event doesn't happen again. So under the modified PUD, it will automatically expire if the PUD, if a building permit or a development permit is not submitted for within 6 years, it's automatically expired. And when it automatically expires, it reverts to the RE1 zoning regulations. But that's actually not a correct statement. That never happened on this property. You heard about the special magistrate and the accusation he reweighed the evidence, but the statute actually provides for what's called a de novo evidentiary hearing. If he wasn't allowed to consider evidence, then he actually would be the circuit judge sitting in appellate capacity, but the statute allows for an evidentiary hearing. So he heard sworn testimony. Everybody was put under oath, including the city planner and my witnesses as well. Mr. Tucker made several remarks or comments claiming that notice wasn't right regarding the magistrate proceeding one. The magistrate proceeding briefly entails two parts. One is a mediation phase, and the second is the hearing phase. Folks that timely petition to become participants, they're not parties under the statute, they're participants. If they timely submitted for that, they don't participate in the mediation phase. So the fact that someone's telling you tonight, well, I didn't get to participate in the mediation phase, well, under the statute, they aren't a party to the mediation phase. And as you all know, the mediation phase was not successful. The case went to mediation. It did not get settled. So it went to the hearing stage. The reference to April, I forget what the date was, April 23rd or April 22nd, 2023. That was the original date of the special magistrate hearing. It was actually canceled at the city's request because my client had made a settlement offer to the city commission, and a shade meeting was scheduled as allowed by law and requested an open city council meeting to consider that settlement offer. That settlement offer was not accepted. The special magistrate proceeding was rescheduled for July 2023, and Mr. Tucker personally attended that meeting. He was given every opportunity to speak. Several members of the public attended, and Mr. Tucker did not raise any objection at that hearing. In fact, the transcript to that hearing is in the binder that's been introduced saying, dear magistrate, I didn't get notice of this hearing. They were provided multiple opportunities to make comments at that meeting. The magistrate was willing to hear from anyone and everyone who was in attendance, and they indicated that the city attorneys had raised all the issues they wished to raise, so they did not need to make any comments. There was a comment by Mr. Tucker that somehow myself and my clients have not complied with a circuit court order because we have not notified the circuit judge within 10 days that the special magistrate proceeding has concluded. Well, the proceedings have not been concluded. You all have approved a settlement agreement at March 25th. Under that settlement agreement, you accepted, under the statute, the special magistrate's recommendation, and this is the step 2 to implement that recommendation by approving a modified PUD. In that settlement agreement, it specifically states that within 5 days, I believe, of this decision, if you were to approve the modified PUD this evening becoming final, that we will dismiss that certiorari proceeding, which will be the notice to the judge. It will be shorter than the time frame. So my client is fully compliant with the court's order. You heard from an individual, and no disrespect, I've served as an HOA president as well. But being an HOA president does not make you a land use expert. What makes you a land use expert is being a certified land use planner, AICP, like your city planner, or my expert, Mr. Bellevaux, or getting a master's in urban and regional planning or an undergraduate degree in planning. There are comments, and I'm almost done, Mayor. There are comments regarding accidents and the safety of the road. If I could go 2 slides. So we had heard about some of this at the last time we were here at the meeting. And it actually was raised at the special magistrate hearing. So the top bullet is from the magistrate's order, just indicating that the city had introduced no evidence or testimony during the hearing to substantiate any alleged accident history on the surrounding roadway network that would somehow be relevant to the case. And again, and he quotes a case law about speculation and conjecture are not competent substantial evidence. But we went to Lake County Sheriff's Department. They have what's called an accident dashboard. It's available online. And we went back 10 years in preparation for this evening to see what accidents have been reported in that area. And those are the findings. Those aren't my data. It's not my client's data. That's Lake County's accident dashboard. So you can see 2014, 0 accidents. 2015, 1. It was at Sleepy Hollow and Recreation Complex entrance intersection, disabled driver. 2016, 1. Siskey Park, lane departure. 2017, 0. 2018, 2 accidents. Sleepy Hollow and Recreation Complex entrance intersection, aging road user. And then the second accident was at southeast end of Sunnyside Road, distracted driver and lane departure. And these are the descriptions that the Sheriff's Department has entered in to their database. 2019, 0. 2020, 0. 2021, 0. 2022, there's between 2 or 4 accidents. And the reason we say that is because the data on the accident dashboard doesn't identify if those are a single event or a multi-car vehicle, multi-vehicle event. So you had between the east end of Sunnyside Drive by the 3-way intersection and Ashton Woods Road, they list 1 commercial vehicle, 2 teen driver, 3 intersection, 4 distracted driver, 5 lane departure. So again, we don't know if those descriptions refer to separate events or a multi-car event. 2023, 0. 2024, 0. So I understand there were comments before, and I understand there were comments this evening, but the data from Lake County Sheriff's Office doesn't indicate a substantial number of accidents being reported on the roadway. There was a comment repeated from the last meeting about one of my clients not being registered with the state of Florida. That corporate entity is one of the property owners. They're a Texas limited liability company. They don't actively do business in Florida. They're a property owner in Florida. And then the last couple things, there was a comment about the trip count. In fact, I think somebody referred to my initials when they said what those numbers were that I talked about. Those aren't my numbers. They're right off of the County Public Works website. They're their trip count numbers. So when they put out a little, the little rubber wire across the road and people drive over it. That's how they get the trip counts. So the trip counts that the county did themselves show that on 2 of the segments, the counts went down from 2021. So again, that's real hard data. We're not speculating like previously when we tried to extrapolate out and said, what will it look like in 2024? Now we know because the county's done the trip counts. And then there were some comments about the recommendation, or whether I've referred to as a recommended order, recommendation and report. The fact is we went through the process. It was a very thorough evidentiary hearing and a very detailed order. It's 40 pages long. And I would encourage the folks in the audience to read the document. Because again, it was on multiple issues that the special magistrate considered the prior decision in his role, listening to the expert testimony, the sworn testimony, concluded that it would be unreasonable to deny my client's project under the statute. And in conclusion, I know you all have a difficult job. You always have a difficult job, whether it's determining millage rates or zoning decisions. And zoning decisions are some of the most difficult that come before you. And I didn't belabor the point earlier in the slideshow, and your city attorney, if need be, can advise you. But a lot of times these hearings seem like there's emotion. There's neighborhood. It's the biggest investment we make in our lives is our house, typically. But these hearings are not popularity polls. In fact, my firm represents city councils and county commissions across the state as special land use council. And that's usually how our clients get in trouble, is because they make a decision based on the popularity of the decision rather than what the role is in a quasi-judicial decision. And a zoning, site-specific zoning, is quasi-judicial. It's not legislative. Legislative is when you adopt a zoning code or you adopt the entire zoning map. The decision's clearly quasi-judicial, and these hearings are not popularity polls. The issue is whether or not we comply with the city's adopted criteria. And that adopted criteria is in 2 places: the city's comprehensive plan and the city's land development code. And you have a detailed order that you voted to accept at the last meeting that opined that we comply with those criteria. And this evening, not a single individual has come up to you and cited a specific section of either your comprehensive plan or your land development code and said, Mr. Spain's client's project does not comply with section 6.1 point blank of the land development code. Your city's planning staff has reviewed this project 5 times now. And each of those times they have recommended approval, and each of those times they have concluded that we meet the land development code requirements, we meet the comprehensive plan requirements. The only requirement, and I put that in quote marks, that was at issue at any time was whether or not we met the Sunnyside task study report. And as demonstrated this evening in the special magistrate's recommendation, that task report was adopted by a resolution that has no criteria. And under Florida law, it's not enforceable or applicable to my client's property. So again, I understand it's a difficult decision. I know voting for my client's project this evening won't be popular with some folks in this room, but I'm here asking you respectfully to do it so that all involved can move forward and move on. So thank you for your time and your patience.
Dan, if you could come back up, please. Do you have any comments to add to that?
No, sir. I think Mr. Arnie misquoted me, but that's fine. This kind of thing happens. So we'll be happy to answer any other questions you might have.
Anyone have questions for Dan? We've already had public comment. Yeah. Yes, when we brought up Mr. Spain. We have somebody yield their time to be with this? We have already yielded. We've had public comment, and then we let the petitioner.
Yeah, go ahead. Just not to take over for the mayor here, obviously, but there is a specific public hearing process That process is we swear in the witnesses. That was done. The next process is we hear from the city. That was done by Mr. Miller. The next step is we hear from the petitioners. That was done by Mr. Spain. Then we move into comment from the public. That was done. Everybody had opportunity to speak. Then the process allows the petitioner to respond, which was Mr. Spain came up. Then the process allows the city to respond. Mr. Miller did that. And now this part of the process is back to the commission for commission deliberation and a vote. So that's the process of a public hearing.
So do we have any comments from the commission with regard to this issue?
I have a couple for our attorney. The present proposal on the floor, if it were to be accepted, would the city be responsible for any type of legal fees on their end?
So no, as part of the settlement agreement that you approved at the last meeting, each party would then bear their own attorney's fees and costs if you accept the proposal here.
Okay. If we happen to go to court and we lost, what would be the possibility we would then be responsible for a portion, if not all, their attorney fees?
Then you may be subject to reimbursing for attorney's fees and costs.
Any idea what those are?
No.
Other comments? Please, sir. This is the opportunity for the commissioners to discuss it. We've already had public comment. So is someone having trouble hearing? Okay, you didn't hear what Jay said at all? Okay.
So the question was whether the city could potentially be liable for attorney's fees and costs in the event that you decided not to approve of this revised PUD and proceed with the litigation and lost, correct?
Correct.
Comments by commissioners?
I guess I'll speak for myself. I can't really speak for the whole commission, but okay, I will speak for myself, not the whole commission. You know, I was on the commission in 2022. We voted it down. You know, there was a lawsuit. I feel like the city gave it a good fight. We now have legal counsel strongly advising us to settle this, and I'm not completely happy. I did think city commission, I'm always learning in this role. I thought the city commission was the final litmus test. I thought we were kind of the common sense logic approach. I voted against this project over the roads. The roads are inadequate. I don't care what traffic engineers, professionals say. The roads in Sunnyside do not support it. But at the end of the day, I can't support spending more money on a lawsuit when I have legal counsel telling me it's a loser. I don't take this lightly, but just wanted to kind of, I guess, get a few things off my chest.
I'd like to make a comment as well. This is not an easy decision by no means, not easy at all. I've listened to all of the comments presented tonight. All parties have a vested interest. I reviewed the timeline from 2005 to present. I reviewed the PUD. I also have read the special magistrate legal opinion and recommendation to approve the PUD. Of equal weight is the advice from our legal counsel and to settle pending litigation. I would be negligent in my duties as a commissioner to ignore the legal advice and potentially navigate negative financial ramifications for the city. At this time, I think it's at the best interest that we move forward, as stated earlier. Thank you.
Any other comment? No more comment. Roll call.
Commissioner Berry,
Yes.
Commissioner Connell,
Yes.
Commissioner Eastman,
Yes.
Commissioner Peterson,
Yes.
Mayor Burry.
Yes. we'll move on to, actually, let's take about 2 minutes. If anyone is leaving, they could leave now. We're going to move on to the rest of the meeting. We'll take 2 minutes. 5-0. We do the best we can, sir. Listen, we're not here to discuss it. I got 2 minutes. Okay, so I don't know. I mean, that's information that is straight off of their website. Mayor, good job. I ain't got it. No. I've been my little people, so it's hard. You just got to. All right, guys, come on. If you come back in, please, we'll move on with the meeting. Okay. We are in public hearings and non-routine items. We're moving on to item B, which is first reading of ordinances. Would someone please introduce 6B1?
Introduced and asked to be read by title only.
An ordinance of the city of Leesburg, Florida, amending and reinstating ordinance number 2018-2 as amended by ordinance number 2018-35 and is further amended by ordinance number 20-14, providing a short title, providing findings and intent, granting certain non-exclusive franchises to Gibson Place Utility Company LLC, Gibson Place Water Conservation Authority LLC, Blue Goose Utility Company LLC, Blue Goose Water Conservation Authority LLC, Okie-Humpkie Utility Company LLC, Okie-Humpkie Water Conservation Authority LLC, and their successors, and assigns, parentheses, each a franchise and sometimes collectively referred to herein as the franchisees, close parentheses, A franchise period of 30 years to construct, own, operate, and maintain certain services and facilities to serve areas within the adjacent to the village's age-restricted development, setting forth the terms and conditions under which such franchisees shall operate, providing for conflict and severability, and providing an effective date.
Grant, if you would please swear in.
Yes, sir, Mr. Mayor. Anybody here who is present and wishes to provide any testimony on any of the first reading items here on 6B of the agenda, if you would please stand and raise your right hand so you could be sworn in.
Yeah.
All right. Do you swear or affirm that all testimony you'll give tonight will be the truth, the whole truth, and nothing but the truth? Thank you all. Thank you, Mr. Mayor.
Yeah. Al, if you would just give us a overview.
Obviously, all these are on first reading. So this is a staff report for item 1, 2, 7, and 8 in this section of the agenda. When we endeavored with the partnership with the villages, brought the villages in, we did several different agreements that associated with municipal services. And we have these agreements kind of scattered throughout different ordinances and the like. The purpose of these ordinances is as the villages has grown in corporate limits of Leesburg, we are trying to consolidate all our different agreements to all the different areas that the villages now owns or will potentially move into the future into basically, I'm gonna lie, but basically 3 documents, but it's really gonna be 4. I'll explain in a second, to where all these agreements can be found. These specific agreements deal with Section 163 of Florida statutes, which on high level is typically what are considered municipal services. So municipal corporations have the right by statutes to provide municipal services, and municipal services are defined by a bunch of different things: fire, police, library, water, sewer, electric, gas. So state statutes gives municipal corporations the right to provide those quote unquote municipal services. As we've endeavored with the villages, we've traded off municipal services. And typically when a municipal service trades off what is statutorily their right to provide, you enter into franchise agreements or you enter into different service type agreements where the city receives a fee or something like that in exchange for the right to provide the service. So these 4 ordinances contemplate essentially 3 things. I'm going to jump to the bottom. 7 and 8 is what we call the 163 agreement. The 163 agreement lays out how we will provide municipal services to all areas of the villages that are in corporate city limits. And it's broken down into 2 sections, Section A and Section B. Essentially, those are the existing 470 properties and then the other properties like Secret Promise, Renaissance Trails, and those type of things that are brought back in. Section 7 and Section 8, or item 7 and 8, show what is item A and B, but basically 7 and 8 cover all of the areas that potentially and probably will be all of the villages in the city of Leesburg. So the 163 agreement lays out all of the municipal services and how we're doing that. If you recall back in the day, our fancy name for that was the hanging chad agreement. It was everything that we didn't contemplate went into one agreement, and that's the 163 agreement. So that agreement contemplates fire services, recreation, impact fees, police services, roads, blah, 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 blah. All of that is consistent and repetitive and the same, summed up in one agreement. So that's ordinances in Exhibit 7 and 8. This specific ordinance deals with franchise fees for water, sewer, and reuse. So as the new residents who live in the city of Leesburg, which is village's property, they will buy water, sewer, and reuse from the entities named in these ordinances. Then those entities will pay the city of Leesburg a 5% franchise fee. All the language in those agreements is all the same that we did in past agreements, and it sums it up. Item number 2 is solid waste franchise. Solid waste franchise is a separate entity brought in by the villages, so we separated it out. So in like really super high layman's language, it's not a partner, it's not a sub entity of the villages, it's a separate contractor. So we've separated out solid waste service with Tri-County Tri-County sanitation. That is essentially the agreement that says Tri-County Sanitation will collect the waste, a little bit different service levels than what we provide, but whatever Tri-County Sanitation provides to those village Leesburg residents, 5% franchise fee back to the city in exchange for providing the municipal services. On this particular agreement, as a side note, the villages did come back to us at a previous time, asked the city if we wanted to physically provide those services instead of franchise them. We put a pencil to that. And for a few different reasons, we felt like the profit margins and the service levels were different than our native load, if you will. So we've agreed that now it's best for that part of the city to remain under the franchise agreement. So that's what section 2 contemplates, or item 2. Items 7 and 8 contemplate all the other remaining services, and what we will do between now and when you hear this on public hearing and second reading is we will double check. I'll be working with Mr. Chandler over at the villages just to double check and double make sure that everything is the same, and the intent again is everything we've improved in the past is the same moving forward, and we'll double check that. I did note late this afternoon one minor little discrepancy only in the fire assessment fee section of that. So I'll get that reviewed. I'll report back to you accordingly. And if there's any modifications or differences, that is done in error, and it will be corrected before the 13th. That's the end of the report, Mayor.
Do we have any questions? Everybody's good with that? Okay. We have had the swearing in, Grant. So was that strictly for this item, or was that for all the items?
Yes, sir. I did that just to cover all of the second reading items in case there was any staff.
All second reading.
Yes, sir. In case there was a staff presentation or audience comment. Yes, sir.
Okay. So this item will lay over. We'll have a second reading on 5/13.
Yes, sir.
Date certain. Okay. So if someone would please introduce.
I'll introduce 6B2 to be read
There
by
you go.
title only.
An ordinance of the city of Leesburg, Florida, providing a short title, providing findings and intent, granting a non-exclusive franchise to Tri-County Sanitation LLC and its successors, and assigns parentheses franchisee in parentheses a franchise for a period of 30 years to construct, own, operate, and maintain certain services and facilities to serve areas within and adjacent to the village's age-restricted development, setting forth the terms and conditions under which such franchise shall operate, providing for conflict and severability, and providing an effective date.
Annie. So under the same discussion, any questions on this? Okay, this will also lay over for a second meeting on 5/13. Do we want to take, we'll take questions on the second reading.
Typically, the questions are taken on second reading, so certainly be sure to show up for that. I think if the mayor wishes to hear any public comment, I'll leave that to his discretion.
Yeah. Would you like to make public comment, sir? Well, come on up.
Bill Polk, 600 Cascade Avenue. I just want to know how you determine the franchise fees. Is it level with the fees that the citizens of Leesburg are paying now? I mean, we're going to get a franchise fee from the villages. correct?
No, so, no. So
The village is just gonna do this, the village is gonna do the services.
correct. It's a
Okay, so
city
then,
clerk,
then we're gonna get a franchise fee from them for the water, et cetera.
yes.
That's correct. So is the level of the expense, the franchise that we're getting, is that level with what I might be paying for my, say, my trash? In other words, I'm paying $18 or whatever for a trash can. And so this franchise, this company, Tri-County, whatever they are, they're gonna charge $18 and we're gonna get a percentage of, say, the profit of Leesburg's, $18. You know, there's somewhere, there's a profit line in there.
Mr. Polk, I don't know the answer to your question.
But you know what I'm talking about?
Mr. Polk, I don't know the answer to your question.
Yes.
What you are asking is a Leesburg resident who is on Leesburg Solid Waste pays about $17.56 a month for
Yeah,
trash.
18 bucks, whatever.
The villages is going to pay Tri-County Sanitation plus 5%.
Okay, so we're,
The Tri-County Sanitation, let's call that X. So it's
Right.
X plus 5%.
Right.
I don't know what X is.
Right.
I will find out. So the city gets 5%.
right, but
Whatever
they're,
X is, we get 5. Is that equivalent to 1756? I don't know. I will find out
Well-
what the answer. I will find out what the answers are: water, sewer, reuse,
right.
and sanitation, and I'll have those compared to what the city pays.
It
I
just,
think they're act. I'm not going to answer because I don't want to.
No, I don't want you to.
Reaction, but I'll get that answer for
I
you.
just wanted to make sure that the current citizens of Leesburg and the new residents are paying equal amounts to get their services.
Understood.
Okay, thank
Someone please introduce 6B3.
I'll introduce and ask to be read by title only.
An ordinance amending the future land use map of the comprehensive plan of the city of Leesburg, changing the future land use map designation of certain property containing 4.72 plus minus acres from low-density residential and industrial to low-density residential for a property generally located east of Flatwoods Road and west of South Street, lying in section 28, township 19 south, range 24 east, Lake County, Florida, and providing an effective date.
Any questions for Dan on this? This is a phase 3, correct? Come on up, Dan.
This is, good evening, Mr. Mayor, again. I was sworn in originally, been sworn out a bit tonight, so I'm.
Yeah, I
it's still
think you're
effective.
good. Yeah, just, you're still under oath, Mr.
Okay.
Miller. Thank you.
Mr. Mayor, this is just a change of future land use only, and going from low density residential and industrial to low density. The planning commission last month approved a conditional use permit for the property. The desire is to put 44 single floor apartments on the property. All we need to do is fix the land use, and it won't be going to 2 stories. So staff is pleased, and if you have any questions, I'd be happy to answer.
Any questions for Dan? This will also lay over till the 13th of May for a second reading. Okay. Would someone please introduce items 6B, 4, and 5?
I'll introduce 6B, 4, and 5 to be read by title only.
6B4, an ordinance amending the future land use map of a comprehensive plan of the city of Leesburg, changing the future land use map designation of certain property containing 10.08 plus minus acres from institutional to general commercial for a property generally located north of US Highway 441 and west of College Drive, lying in section 15, township 19 south, range 25 east, Lake County, Florida, and providing an effective date. 6B5, an ordinance of the city of Leesburg, Florida, changing the zoning on approximately 10.08 plus minus acres from P public to PUD planned unit development to allow for commercial uses, including restaurant, retail, and indoor storage for property generally located north of US Highway 441 and west of College Drive, lying in section 15, township 19 south, range 25 east, Lake County, Florida, and providing an effective date.
Dan, if you'd please come.
Thank you, Mayor. These next 2 cases would be a small-scale comp plan and a PUD zoning. The subject property is north of Highway 441, right across the street from Cracker Barrel. The city currently owns the property. and basically wants to sell off the property, do a lot split. City has no plans to utilize it, therefore it's being sold. The future land use, because it's old airport property, is institutional. That will go to general commercial. The zoning will go from public to planned unit development. Again, it'll be split into parcels later and later platted. The permitted uses that we've worked out with the developer or the proposal, general retail, restaurants, pharmacy, medical, those typical uses such as that. I would like to clarify one use, please, to modify the outdoor storage wording to add mini warehouses. I think we already have some wording in there for outdoor storage, but what we meant to have was mini warehouses with outdoor storage, because many warehouses already have outdoor storage. And we do have architectural standards, dark sky lighting, irrigation requirements, and everything else in this standard PUD. Second reading is May 13. Miss Andy?
Yes, sir.
Questions for Dan on this? All right. This again will lay over until 5:13. So someone would please introduce 6B6.
Be read by title only.
An ordinance of the city of Leesburg, Florida, vacating a 7,367 square foot portion of Park Avenue generally located between West Meadow Street and the city's Fountain Lake Bike Trail, as shown on the official map of the city of Leesburg, Florida, recorded in Plat Book 2, page 19 of the Public Records of Lake County, Florida, and providing an effective date. Excuse me.
Thank you, Ann.
Yes, sir.
Any questions for Dan or for Al on this? Everybody okay? This again will have a second reading on the 13th.
Yes, sir.
All right.
I'll introduce 6B7. Read by title only.
An ordinance of the city of Leesburg, Florida, requesting for a Chapter 163 Florida Statutes Development Agreement amendment for the villages of Westlake Area A to incorporate the property known as Secret Promise with other adjacent properties, to update the agreement to reflect year and remove information no longer needed, to clarify the definition of VLC, Villages Land Company, to include the affiliates of VLC, to add references to community support districts which allow non-age restricted residential uses, to incorporate and update the provisions that were contained in Chapter 163 Public Facilities Agreement between the villages and the city. The Public Facilities Agreement and the amendments will be terminated when this Chapter 163 Florida Statutes Agreement amendment is completely and fully executed, to update the agreement to reflect the current requirements in Florida statutes for Chapter 163 agreements. This request does not include changes to population density, building height, or intensity for property generally located north and south of Florida Turnpike, west of County Road 48, and east of the Sumter County line, as legally described in sections 6, 7, 8, 9, 16, 17, 18, 19, 20, 21, 29, 30, 31, and 32, Township 20 South, Range 24 East, Lake County, Florida, and providing an effective date.
Again, this will lay over until 5:13. Will someone please introduce 6B8?
I'll introduce 6B8 to be read by title only.
An ordinance of the city of Leesburg, Florida, request for a Chapter 163 Florida Statutes Development Agreement amendment for the villages of Westlake Area B, to update the agreement to reflect year and remove information no longer needed, to clarify the definition of VLC, Villages Land Company, to include the affiliates of VLC, to add references to community support districts which allow non-age restricted residential uses, to incorporate and update the provisions that are contained in Chapter 163 Public Facilities Agreement between the villages and the city. The Public Facilities Agreement and amendments will be terminated when this Chapter 163 Florida Statutes Agreement amendment is completely and fully executed, to update the agreement to reflect the current requirements in Florida statutes for Chapter 163 agreements. This request does not include changes to population density, building height, or intensity for property generally located north and south of the Florida Turnpike, west of County Road 48 and east of the Sumter County line, as legally described in sections 6, 7, 8, 9, 16, 17, 18, 19, 20, 21, 29, 30, 31, and 32, Township 20 South, Range 24 East, Lake County, Florida, and providing an effective date.
Again, this will lay over until 5/13. Let's move on to section 6C, non-routine items, which we have none. Informational reports. We have financial reports from January and February from 2024. Are there any questions on either? No questions. City manager items. None for you tonight? All right. City attorney items, I'm sorry, I got them backwards.
No items, Mr. Mayor. Thank you.
Roll call.
Commissioner Peterson,
Nothing tonight.
Commissioner Barry. Tonight. Commissioner Cunnell,
No.
Commissioner Reisman,
One thing, just hope to see everyone out at Bike Fest this weekend. That's it.
Mayor Burry.
Nothing tonight, thank you.
Move for adjournment.
Got a second?
Second.
Uh-oh.
I guess we're going back to sleep.